Everybody loves to go to probate court, right? Yeah, I didn't think so. Making plans for your estate is vital, however, and is part of being a good steward of the resources that God gives you. In this episode of The Help Desk, Dillon McClain, a lawyer with the Arkansas Baptist Foundation, breaks down the process of creating an estate plan that will help you leave a lasting legacy.
I usually start off by giving a little background on the foundation because most people don't even know that we exist or who we are. And so the way I explain it is that we're kind of the trust department for the Southern Baptist world in Arkansas. And so we manage all the endowments and scholarships and reserve funds and things like that for churches. But then we also serve individuals like you through estate planning and hopefully serving as kind of a sounding board for technical advice and technical things. So I'll go ahead and get started. So of course, what we do is promote stewardship, and if you haven't read the Baptist Faith and Message, there's a specific section on that. And we really like the way this reads, and so I'll start there in the second sentence. It says, Christians have a spiritual debtorship to the whole world, a holy trusteeship in the gospel, and abiding stewardship in their possessions. They are therefore under obligation to serve him with their time, talents, and material possessions, and should recognize all these as entrusted to them for the use of glory of God and for the helping of others. And according to Scriptures, Christians should contribute of their means cheerfully, regularly, systematically, proportionally, and liberally for the advancement of the Redeemer's calls on earth. And so that's a lot of words. But where I come into play as the attorney is the systematic part. So I'm here to help you set that up and make sure that things go according to plan, and hopefully we avoid probate in the process. So, of course, reading this part, we all know this, and hopefully I'm preaching to the choir about we know that we're supposed to be good stewards with what God has blessed us with. So, also just a little background on the foundation and our services. So, like I said, we have services for ministries and then services for individuals. And so here are some bullet points on some of what we do. Institutional consulting and guidance, gift investment administration and oversight, and resource for tax, finance, estate planning, charitable giving, and legal and governance issues. So a lot of that may sound like a lot of nonsense, but essentially we help advise churches, institutions, and things on their reserve funds, their endowments, their investment policies, things like that. And then, of course, if anyone is trying to leave something to your church or ministry other than cash or check, then that's where we get involved because of the kind of complex or complicated nature of that type of transaction. And then also just serving as a reference. So we have a CPA, an attorney, CFP, people who are familiar with kind of complex matters that some churches just aren't equipped to handle. So we're here to, if we can't find the answer or don't know the answer, we can at least find someone who does have the answer. So you can use us as a reference. So for individuals, like William said, that we provide free estate planning for anyone in denominational service, and that's for you, and your spouse. So that's wills, trusts, the necessary deeds, power of attorneys, all those sort of things when it comes to your estate planning. And then anyone who's not in denominational service, so like just a lay person, then we will help and provide drafts for those individuals who are wanting to make a gift to further the kingdom. And then also in certain situations, we're there to serve in a kind of a trustee or agent role. And so that's when the majority of the estate is charitable. So now what you guys actually want to hear about is that's estate planning. So if any point there's a question, raise your hand, because if you have the question, somebody else does, and I prefer to kind of do the Q&A rather than just plow through slides. So just stop me if I keep on rambling on and I'm not paying attention, you have your hand up. Okay, so estate planning. A lot of people have a lot of preconceived notions of what that is. Or how it goes because they heard from so-and-so or their neighbor how estate planning or probate goes. And I'm going to try to debunk some of that today. But estate planning, when it's boiled down to the basics, it's just determining who's going to get your stuff, what they're going to get, and when they're going to get it. And so That's just a simple transfer of assets to the next generation or to your beneficiaries or heirs. Of course, this is our last opportunity for stewardship because we know we can't take it with us. So we should have a plan and try to steward that well, especially in preparing the next generation and even tithing to our church. And it's also a time for us to plan for our incapacity. And so a lot of us may not have power of attorneys and things like that where an agent can make decisions for you. And I saw a statistic the other day that said now because of our life expectancy, about 70% of us are going to be incapacitated at some point or another. So we need to have these documents in place so our loved ones can take care of us. Whether you're 18 or 108, I kind of recommended plan for incapacity. Okay, so whether we like it or not, our things are going to transfer somewhere or to someone when we pass away. And there's 3 legal ways that things will pass. And the first one is intestacy, and that's just the fancy words meaning that you don't have a plan, which is about 50% or more of the people, at least nationally, don't have any type of plan in place. And so in Arkansas, if you don't have a plan, don't worry. The legislature has written one for you, and it's in our statutes, and your things will pass according to Arkansas law. I don't recommend that, so let's not do that. Another way that your assets will pass is either by a will or a trust. So those are written documents that you execute during your lifetime. Of course, this is where you name your individual beneficiaries and people who are going to serve in your agent and fiduciary roles. And then also the third way is by contract. And a lot of people don't realize that they've done this even when they set these things up, but it's kind of it's a contract between you and a bank or you and the life insurance company. But when you put a payable on death designation or you have a beneficiary statement, say at Guidestone, then those assets will automatically go to the beneficiaries that you named once a death certificate is provided. And so that's another way that assets will pass. So in Arkansas, these are all Arkansas specific, even though most estate planning laws are almost uniform, or most of them are uniform these days, but these are Arkansas specific. So you have to be 18 and of sound mind, and it must be in writing, or it may be, and it can be in your own handwriting, although I don't recommend that. So the 18 part is usually really, really easy to figure out. The sound mind part is not. And so what I say is do a will as early as possible. So somebody like me or another attorney doesn't have to figure that part out, because that's when it gets tricky. Is towards the longer you wait, the more diagnoses you have that would indicate you don't have that capacity, the more likely that there's going to be challenges and you're going to end up in court. So, if weird things start happening, if you have a natural kind of distribution to your kids, hopefully that everyone gets along. But you would be surprised what happens when money is involved. And I actually wrote an article on that not too long ago based on a personal family experience that mentioned about how I recognize the total depravity of man, especially when it comes to money and estates. So anyway, don't wait too long until we can't figure out whether or not you have sound mind. Let's do it early, and let's have the family members involved and communicate the plan, and so everybody's on board with what's going on. Like I said, it can be handwritten, and that's called a holographic will. So if you're at last ditch effort, you're at the hospital, and you don't think you're going to make it, write something down. That is legally effective. You say, this is the last will and testament of John Smith, and I give everything to my kids in equal shares, and I want both kids to serve as my executor. Sign and date it. That's effective. Now, if you start getting complicated with it may be subject to interpretation. But if that's a last-ditch effort, like William said, we do this for free. There's no reason for you to write your own. So let's write a plan that we know is legally effective and will carry out your intent. So the only reason you would write your own is if that's your only option. So in your will, this is where you name your executor or personal representative. This is the person who's going to administer your estate. You appoint someone, usually your spouse and then maybe kids or something like that, to kind of administer, collect everything, and distribute it according to your estate documents. Of course, this is where you name your beneficiaries, who's going to get grandma's quilt and who's going to get, guns, and then remainder to the kids in equal shares, whatever you put in there. And then if you have minor kids or there's dependents that you have, you can name guardians in your will as well. And so this is where I think young people wait too long, or usually this is the only way that I can get a young person to execute an estate plan, is because they have young children and they don't want the state to determine who's going to be their guardian. So it's also a place where you could appoint those type of fiduciaries. And these are the last two things that people don't realize, I think, the most, is that for a will to be effective, it has to be probated. It has to go to court. So a lot of people think, well, I have a will. I'm not going to end up in court because my kids I hear that a lot. My kids get along. We're not going to go to probate. Well, that's not the rule. That's not the law. If you have a will, in order for it to be effective, it has to go to court, and the judge has to sign off on it and say, this is their will, and okay, executor, carry this out. So you sign it and put it in a drawer, and that's all well and good, and your intent will get carried out, but it's still going to go to court. So we'll talk about avoiding probate here in a second. And it's also only good for 5 years from the date of death. And a lot of people say, well, why does that matter? It's because if you put it, hide it someplace and no one knows where it is, it's not going to happen. And the specific example that I have of this is that there was a will that I found and saw the date of death was about 4 years and 51 weeks prior. And I said, I randomly found this. Well, I better check this out just to make sure because of the 5-year rule. Well, anyway, it had a gift of $100,000 to a ministry here in Arkansas. And whenever I went back and kind of researched it all, well, long story short, all that money was gone. And the kids didn't know that will existed. And ministry did not get that $100,000 because it got past the 5-year date, and it would have cost probably more money to try to retrieve that money from the family than it would to just let it go. So all that to say, if you do have a will, tell your kids or your loved ones where you're keeping it, because that could happen. And then if they can't find it, then it's presumed that it's been lost or destroyed, and so then you go by intestacy. And just to kind of define what probate is, a lot of people have this kind of, almost like this mythical idea of what it is, and that it's this big evil government scheme. But all it is the court-approved transfer of assets, is the simplest way I can define it. And so again, you submit your will, executor carries it out and follows all the rules by hiring an attorney and filing all the necessary paperwork, and then getting everything transferred to the beneficiaries according to the will. So that's probate. It's not as the big bad boogeyman that everybody thinks, but it is costly and it is time consuming, and I'll kind of go through that here in a second. So the second way that you execute something during your lifetime to carry out your intent with your estate is through a trust or a revocable trust. There's all kinds of trusts, but really today I'm just talking about revocable and living trust. So in a trust, there are 3 parties. There's the grantor or trustor that creates it. There's the trustee that controls the trust assets, and then there are their beneficiaries. So generally, you are 3 in 1. You are like a trinity of the trust, and you're you have different roles depending on which way you're acting, but and whatever capacity you're acting. But you have certain powers and certain duties depending on which role you're in. But generally, in the beginning, you're 3 in 1, and so you don't lose control. I get that question a lot. I don't want to create a trust because I don't want to lose control. Well, there are certain trusts where you do lose control, but in a revocable trust, there's really no difference. It just changes the way you're signing. In what capacity you're signing. So yeah, there's three parties, and then you name successor beneficiaries and successor trustees to, carry out your intent once you and your spouse are both deceased. And so this can be something that you kind of operate under during your lifetime, or you can create a testamentary trust that kind of springs into being at death, and that's all the testamentary means, is that it just springs into being once the individual has passed away. So why would you want to trust? Is one, it avoids probate, kind of what I talked about. And why you want to avoid probate is because it's costly and time consuming. So I would say just to get started around here in Central Arkansas, most places in Arkansas, just to get started, you're probably they're going to have to pay $2,000 up front to start the retainer for somebody doing probate. And that's if they're working on a contractor rate. Some attorneys won't even do probate unless you allow them to take the statutory fee. And that means it's written in their fees are written in the statutes. And guess who wrote the statutes? The attorneys did. It's very favorable. So if you ever want me to do probate at a statutory fee, call me. But it's a very time-consuming process as well, because I would say the soonest I've ever completed a probate process is probably 9 months. So the reason why is that you have to wait on a death certificate to get anything done, and that usually takes a month at least. And then once you get that, you got to hire the attorney. The attorney's got to draft everything to get it started, and then you got to file everything with the court, and then they have to approve the executor. And then once they approve the executor, you have to file something with the newspaper, and you got 6 months from that time for creditors to make claims. And then once that 6 months is over, then you can start kind of wrapping everything up. That's if everybody's getting along and kids aren't fighting over grandma's quilt. So if there are any issues, then it can stretch out years and years and years, and which the longest one I've ever done is a little over 2 years. And that's just because of the size and complex nature of the estate. But if people are fighting, it could go on forever and can get pretty costly. Yes, ma'am.
Okay. When my mother was bedridden, I went through the house, took pictures of everything that might have had value or sentimental value, and had everybody come through and sign which picture they wanted when she deceased. Is there any legality to that, or is that just a family-friendly thing?
Yeah, so I guess if they were doing that at your mom's instruction, then yeah, I would say it's okay. But if it's just kind of the siblings kind of dividing stuff. Now, let me say this: did she have a will or anything, or did she no plan?
I don't know.
Okay, so no plan. Still, kids are natural heirs anyway. So if kids are the only natural heirs, there's no plan that says not going to my kids in equal shares. And kids get along, and that's the way they want to distribute it. There's no one that can challenge that, really, when it comes to personal property, because you're the natural heirs anyway. But in general, unless it's where I was getting at is if it's not the intent of the individual, then it may be different. Or if she had a plan that said, well, I give 10% to my church, 90% to my kids in equal shares. Well, the church could say, well, what was 10% of that value of those expensive personal property items that you gave away? But if she had no plan, kids are the natural heirs anyway. There's no issue unless brother starts fighting over who gets grandma's quilt. So, okay. So yeah, trust. So it avoids the cost. I think so if you hire someone to do a trust, in this area, I would say a minimum, you're probably going to pay $1,200. So I would say it's still an investment over what you're going to pay for probate for sure. And then also it administers the estate much, much quicker. Because I would say you're probably looking at a year before everything's distributed and finalized. But with a trust, you can do it. You can usually do it much, much faster. And the other kind of pro for a trust is that it's private. So if a will or intestate estate is filed, I can walk down to the, well, these days everything's digital. I was going to say walk down to the courthouse, but now I can probably just go on my computer and I know where to go and I can find everything and say, okay, look, everybody's getting this. Oh, John's fighting over grandma's quilt and they're fighting, I can kind of see everything and it's a public record. But a trust is private and no one's entitled to that document except for maybe financial institutions. They may request certain information about the trust. So that's another advantage. There are certain type of irrevocable trusts that avoid taxes, and I'll talk a little bit more about those in a little bit. But the revocable trusts that I've been talking about, they do not avoid taxes. They do not protect your estate from Medicaid or anything like that, or have asset protection. So that's a different animal. And if you have questions about that, you can email me and we can talk about some of those issues. But for now, I'm just talking about revocable and living trust. Also with a trust, it's a great way to provide for minor children or to provide for adult children who act like minors. Because through a trust, you can actually control the distributions. You can say a monthly payment, or they only get necessities and income, or, you can restrict it in certain ways, or they only get it at age 30, 35, and 40, whatever you want to put in there. But through a will, you can do those same things, but you have to go through probate to create that. So if you're going to try to restrict distributions to the kids, then you might as well set up a trust now, because it's going to avoid probate and be less time consuming. And it's also, you can, in the same way, you can kind of control or make distributions to charities. So it's a great way to do that as well through a trust. So unless anybody's got any more questions about wills and trusts, I'm going to move on to planning for incapacity.
You did say that even the revocable trust still has to be probated, though, right?
No, so a trust does not have to be probated. No. So let me back up. So the idea is when you create a trust, and I use the analogy of you create this trust bucket, and you get everything in the trust bucket or payable on death to the bucket. But if you leave assets outside of that trust in your individual name, those assets still have to be probated because they're left in your individual name. So the goal is you set up the trust, you get everything into that trust bucket, or use a payable on death designation to the trust bucket. Otherwise, you have a trust and you're going through probate or some type of court-approved process. That was my qualifier for that. So generally, no. If you have a trust, you put your assets in there, no probate. But say you come into my office next week, we set up a trust, we get everything in there. We get the real estate in there, but then you downsize in the next couple of years. You buy a new house, and you forget about that new house and don't deed it to your trust. Well, then that one piece of real estate is going to go through probate, and it's the same process whether it's a $10 million estate or a $101,000 estate. It's going to be the same probate process. So once you set up the trust, you have to kind of remember to keep reviewing your assets to make sure they're titled correctly and inside the trust bucket.
So everything, for example, when you set up that trust, you've got to list your house address, and you list your cars, if they're paid for to go to your kids, motorcycles, your boats. You got to list all that stuff in a trust.
So you don't necessarily have to list it, but you do have to change the ownership of it. So, for example, your bank accounts, I'm assuming they're in your individual name or you and your spouse's name. And so you would either change that account to the ownership of your trust now, So you would go into the bank branch and say, this is what I want to do, and fill out the correct paperwork. And you would change the ownership to the trust, or you would leave it as is and put a payable on death designation to your trust. So it automatically transfers to that trust. And so you kind of do that with all of your accounts. But for personal property, there's two things you would do. One, I do an assignment of personal property that says I give everything to my trust. And then also there's you can use a memorandum that says I give my guns to nephew, I give my jewelry to whoever. And that legally is effective to transfer those personal property items as well. So you can be specific if you want to, but generally there's a paragraph that says I give my personal property to my kids in equal shares, and then I provide a share for each kid and through my line of descent kind of. But you don't have to list them, but if you have specific items you want going somewhere, then you would list them out.
You do a trust in Arkansas, move to another state, how does that?
Yeah, so generally a trust crosses state lines, and other states will recognize it. They just may interpret according to, they may try to interpret it according to the law. So generally, if it says it's an Arkansas trust and you move to, say, Florida, I would say maybe update it, just for income tax reasons. But you can change the situs of the trust to the state that you're currently a resident of. But if you create an Arkansas trust and move somewhere else, a lot of times they will interpret it according to where it was created. But when it comes to real estate or assets that are specifically located in that state, then they will interpret according to that state's law. So depending on where you go or what's more favorable, you might change that. But it does cross state lines.
Is there some advantages to going ahead as you get older, like transfer your house into a daughter or son's name, or does the trust take care of that? I'm thinking about if you get incapacitated, there's a 7-year thing now, I believe. I don't know if that's a related question.
Yeah. So unless maybe somebody didn't hear me. He said, "What about as you get older, transferring things into your kids' names or transferring out of your name?" Kind of I think he was referring to the Medicaid look-back period, which so. Unless I've been hearing about the 7-year rule, but I think it's still 5 right now. I think they're talking about increasing it, but I think it's 5 years right now. And so there are ways to. It's basically if you're trying to get qualified for Medicaid, then you can transfer. And this is talking about long-term care Medicaid. So if you're going to a long-term care facility, and you want Medicaid to pay for it. You can only have a certain amount of income and a certain amount of assets. And so if you want to protect, and put in quotation marks around that, those assets, then there's certain things you can do to transfer those assets. And basically you're bankrupting yourself on paper, so you qualified for that Medicaid. So there are ways to do that, but if you... on the house, I wouldn't recommend doing that for the kids, not now, because personal residence is generally exempt from the Medicaid application and the calculations. As long as you check on the application that you intend to go back there at some point, which is what you do, then that's exempt from their calculations. So I would say if you have other real estate that you're wanting to protect, then you could potentially deed it to your kids and reserve a life estate for yourself, or deed it to an irrevocable trust. But your personal residence, I would not do it that way. Yeah. And we can talk other strategies around that too. Okay. So unless we have more questions, I'm going into incapacity. Okay. So planning for your incapacity, there's really 3 documents that you're going to want to have. And I recommend these 3 documents, whether you're, like I said earlier, whether you're 18 or 108. So one is durable power of attorney, and this is kind of for finances or personal affairs. And so in this document, you're naming an agent who can act as if they are you. they can buy and sell and transact and do things on your behalf. And so this can be immediate. And so if you are, 90 years old and you need help with things and you're going to execute one of these, I would say make it immediate. Let your kids take care of things for you immediately. But you can also execute one that's springing, meaning that the agents that you name can only act upon your incapacity. And so a lot of times what I do is I make it immediate for spouse, because I assume people trust their spouse, and then I make it springing for any successor agents. So that way spouse can transact on their behalf, take care of the retirement accounts and things like that. But then for their successor agents, it's springing and only upon, they can only act upon incapacity, or if the principal, the person who created the document, signs another document that says, okay, I want my successor to act for me now, then that's another way that that person can act. And then next is your healthcare directives. And the first one is a healthcare power of attorney. Again, you're naming an agent who can make healthcare decisions for you when you can't make them for yourself. And then also access insurance and medical records if necessary. And then a part of the healthcare directives, I always draft what's called a living will, which basically states what you want to happen when you get into a kind of permanently unconscious state and they don't think you're coming back. And so I usually use a form that's pretty simple. It just says whether or not you want artificial hydration and nutrition, so feeding tube and IV fluids to kind of sustain life, and you check whether or not you would want those things. And it's not on here, but there is a form on the Department of Health's website. The Arkansas legislature created a form in 2017 called the POLST, P-O-L-S-T form, and I would recommend at least doing that because I like it when the state provides a form, because that means they have to follow it. And it stands for the Physician Ordered Life-Sustaining Treatment Act, I think is what they came up with. And it's a little bit more detailed than the living will that I do, because it also includes a DNR, a do not resuscitate order. And that's because that's a medical order, and I can't draft a medical order for you. That's something a doctor has to sign off on. But what you do is you can go on the website, the Department of Health. If you just Google or search for POLST Arkansas form, it'll take you to the Department of Health's website. You fill out that form, take it with you to your primary care physician. They sign off on it, and it goes in your medical records. And so I would, at a minimum, recommend doing that. And you can also execute that along with, say, the healthcare directives that I mentioned here, and they work in conjunction with each other. But just make sure they say the same thing and don't conflict. Because if they do conflict, then the legal documents win. So make sure they line up.
I have one question.
Yeah.
On the power of attorney, like you were speaking of, with the husband and wife are first as power of attorney for one another, and then they do a succession of spring, which you spoke of. What about death? Does that power of attorney still continue after their death? As far as incapacitated, or is that? So
at death, a power of attorney ceases to exist because you can only serve as an agent for a live person. At that point, either executor or trustee kicks in if the person is deceased.
Do any of those forms have to be filed with anybody, or are they just in our file?
So Arkansas doesn't require any kind of filing. You can file them with the circuit clerk if you wanted to, but they charge $15 for the first page and $5 for every page after that. So at a minimum, what I would do is just have multiple copies out there, give them to your kids, give them to your loved ones, and then give them to your doctor. Keep them in an email. I mean, just have them everywhere. And then when you go to the hospital, or I know we don't always plan to go in the hospital, but if we can, take them with you. And they usually ask you that if you're going in for surgery anyway. But if you do that POLST form, then they are supposed to, I think they're supposed to put it in your medical records at the doctor. So eventually it'll get to where it needs to be.
If you're giving those documents to family members, you had mentioned where you can just list like I want all my assets to go to the trust, you're not having to be specific where they might know what your assets are and the values of those. Does that make sense?
So when we're talking about listing assets, so you don't have to list them. Some people do. They do like a Schedule A attachment to it to say, here are my assets and the values, what I'm transferring. And a lot of times I don't do that because that changes so much. So what I tell people to do is create a treasure map for their loved ones to follow. And so it says, my bank accounts are at Bank of America. My retirement account is at Guidestone. My life insurance is at Guidestone. You know, and just kind of list it out. And so I have this document. Mine's morbidly titled "In Case I Die," and I send that to my wife and my successor trustees every year. And it basically, mine's a little bit more detailed since this is kind of what I do for a living. It actually instructs them on exactly what they need to do. And so, but I just kind of have everything listed out so that they know, okay, I need to go to the bank, give them a death certificate, and collect it and put it in a trust account. I need to, and so it just, it's a good exercise to go through because one, it shows you what you have. A lot of people don't realize what they have, and then two, it'll help you when you. I always say do kind of an annual checklist of, okay, are all my assets in the trust? Are all my ducks in a row? So that you know things are going to go according to your intent, and then also for your kids to follow it. Because now, most people these days get all their statements online, or get a majority of their statements online, and so. Previously, and when I first started, it was pretty easy to figure out where everybody had assets because I would just wait on the mail. I would forward the mail, wait for statements to come in, and then I could find everything. Well, now everybody just sends everything to their email, and guess what? Google and Yahoo and all, they don't want to turn over everything to you, and so you actually have to get appointed by the court to request things from those providers, and so there's a lot of litigation and I'm chasing a rabbit here and I apologize, but there's a lot of litigation and a lot of laws and things being written about digital assets right now, which includes your email. So make sure that if you are getting statements sent to your email that somebody knows how to get in there. And I didn't say that because technically you're violating federal law if somebody signs in that's not you on your account. But if you have a Google account, you can actually assign people who can access your account legally. So, I'm sorry, I was being recorded, I think, so I'm going to get in trouble. And you can also do that with Facebook and other things. But anyway, that's another topic because we're almost out of time. Okay, so long answer short, yes, have a list of assets, but I don't necessarily list them in the trust documents. Okay, so I was going to talk about charitable giving for a little bit, but I'm going to jump forward to some visuals of all this to save a little bit of time. So these are some of the kind of charitable instruments that the foundation uses to make charitable gifts, and there's different strategies with all of these. But a donor advised fund is a great way to set up a charitable gift either now or through your estate. I just wrote an article about this as well, about taking advantage of the standard deduction. Now, I don't know if you guys are aware, but it's basically for a married couple, it's jumped to $24,000 at the federal level, the standard deduction. So most people, or a lot of people, won't be itemizing anymore because they don't have enough deductions to meet the federal standard deduction. So one way to do that is by using a donor advised fund and do what they call bunching your charitable giving. So you would basically put 2 years of giving into a donor advised fund and then do your same distributions over the next 2 years. So basically you're giving your charitable giving every other year. You get a deduction that bumps up your charitable giving in 1 year, even though you're giving it out over time. Does that make sense? Okay, so using the visual, you give Walmart stock or you give cash to the donor advised fund, you get an income tax deduction the year that you give it, and then you tell us where to send it. So you tell me, okay, send $1,000 a quarter to my church. Send $100 a month to the children's home, whatever it may be. We administer those, and there's different strategies in using a donor advised fund, but that's kind of the new one, is trying to take advantage of the standard deduction limits now. And then also I use this as a receiving vehicle for charitable giving. So some people say, I want to give 10% to my church. Well, people change churches, or they change their minds a lot over time. So a lot of times I'll say 10% to the John Smith Charitable Giving Fund. And then that way you don't have to keep updating your estate documents. All you have to do is update that one donor advised fund agreement that's on file with us, and then we send it to where you tell us to at your passing. So that's a donor advised fund. Okay, a charitable gift annuity. Either one, you can set up a charitable gift annuity, and all it is an agreement between us and the people that set it up. You give assets like the Walmart stock or the cash or whatever it may be, and you get a guaranteed income stream for the remainder of your life or joint lives. And so no matter what, if you live to be 170, we're on the hook for making that payment. So you get a set payment based on your life expectancy, and you get a deduction for giving that amount to the charitable gift annuity. And when you pass away, if there's any left over, it goes to the church or to the ministry of your choosing. So that's a charitable gift annuity. There's a charitable remainder trust, which works pretty similar. Same way you gift it to the trust, you get an income stream. You get a deduction in the year that you give it, and then if there's anything left over, when it's all said and done, then it goes to the charity of your choosing. And there's different strategies for using one over the other, but I'm trying to skip over to the last few things because these are probably something you're more interested in. So I always hear things about state taxes and the death tax, and people are always worried about that. So for 2019, you can give over unless you have over $11.2 million in your estate, then we don't have to worry about the estate tax, at least federally. And Arkansas doesn't have a estate tax, or at least it's tied to the federal exemption. So, and that means a couple can pass over $22.4 million without having an estate tax issue. So all that to say, I don't know about you, but I don't have this problem, and I don't think I will unless I win the lottery this week. So at this point, don't worry about the estate tax, but that doesn't mean in the future. So this is the law until to the end of 2025. Who knows what's going to happen in between then, or how many different sessions of Congress will change that rule. But for now, this is the rule. And if it does go down, I mean, it's still probably going to go down. When they said if Hillary won, then it was maybe going to go down to $3 million per individual. So that would have been a total of $6 million for a couple. I still don't have that problem, and I won't probably ever have that problem. So all that to say, most likely most of us will never have an estate tax problem unless something dramatically changes. And then also gift tax. If you are giving you can give $15,000 per individual per year and owe no tax. But if you give more than that, then you owe tax based on the amount over that $15,000 that you gave. And a lot of you guys are probably thinking, well, I don't give $15,000 to my kids. But if, say the example that the man asked earlier about putting my daughter on the deed or putting their name on a particular asset, well, that's a gift being made. And so if they come back, if you get audited and they come back and say, okay, that was a gift and that was worth this amount, you may owe tax on that gift. So make sure before you do. Yep.
You're saying you may owe tax. You mean the recipient owes tax?
No, the giver. The giver owes tax. So if you make a gift, say if you make a gift of $20,000 to your kid, then technically you owe $5,000 in gift tax. But you can file a gift tax return and not have to pay the tax. So if you do make that kind of gift, make sure that you work with your CPA or tax preparer to file the correct return so you don't owe any tax. Yeah, and most people think that's crazy. I give something away and I have to pay the tax. Well, welcome to America. Yeah. So And then, okay, so I'm going to skip to this because we are out of time, and I think this is important given this is at a retirement kind of planning seminar. So if you guys, this is something a lot of people don't know about, and so if you have an IRA or you can convert your retirement account to an IRA, this is the most likely the way that you should be doing your charitable giving, especially if charitable giving is part of your budget. So if you are 70 and a half or older, meaning that you have turned 70 and a half and you have an individual retirement account, then you should be using what's called a qualified charitable distribution, or sometimes referred to as a charitable rollover, to make your charitable gifts. So if you have an IRA, then you can give directly from that IRA to church or to ministry or wherever you're giving charitably, and it excludes that amount from your taxable income. So because a lot of people who are 70 and a half are taking the required minimum distribution and then they're paying a tithe on after-tax dollars. Well, if you do it, the charitable giving through a QCD, that part satisfies all or at least a portion of your required minimum distribution, and it removes it from your taxable income. So if it's part of your budget and you have an IRA and you're 70 and a half, you definitely should look into this and make QCDs rather than giving charitably with after-tax dollars.